I have presided over thousands of disputes, listened to countless excuses, and watched people swear under oath with absolute confidence. Most believed they understood what evidence meant. Most were wrong. But there is one afternoon I still remember with remarkable clarity because a single sentence echoed through my courtroom before everything unraveled. "You can't prove it." Karen said those words while looking directly toward the bench. Not with fear, not with uncertainty. She smiled as if the case had already ended in her favor. After decades in the courtroom, I had learned that confidence and innocence are not always companions. Sometimes confidence is simply the last shelter of someone who believes the truth has already been buried. If you've ever wondered how an ordinary sheet of paper can dismantle an elaborate lie, stay with me, because what unfolded that day reminded everyone in my courtroom, including me, that facts are patient. They don't panic. They wait until the right moment. The courtroom was unusually quiet when the bailiff called the matter before me. Karen walked in wearing an expensive blazer and carrying herself with practiced composure. She acknowledged no one except her attorney. Her posture suggested she had rehearsed every answer before ever stepping inside. Across the aisle stood Daniel Carter. His suit wasn't new. His hands betrayed weeks of stress. He wasn't trying to appear impressive. He simply wanted someone to believe him. Those differences matter more than people realize. After years on the bench, I stopped judging credibility by clothing, confidence, or polished speech. I watched eyes. I watched hands. I watched the moments between questions when people forgot they were performing. Karen never once glanced toward Daniel. Daniel couldn't stop looking at Karen. That alone told me nothing, but it made me curious. The lawsuit itself appeared ordinary on paper. Daniel claimed Karen owed him thousands of dollars connected to a private business agreement. Karen insisted the arrangement had never existed. According to her, Daniel had misunderstood friendly conversations and invented promises that were never made simple enough. One person's word against another. Cases like that arrive every week. They rarely become unforgettable. As opening statements began, Karen's attorney spoke with remarkable certainty. "There is no written contract, no enforceable agreement, no proof." Those three phrases repeated again and again until they almost sounded like established facts instead of arguments. Then Daniel stood. He wasn't a trained speaker. His voice trembled during the first few sentences. "I know how this looks, Your Honor," he admitted, "but I trusted her." Trust. That word always carries unusual weight in court. Contracts protect business. Trust exposes character. Daniel explained how Karen had convinced him to invest in what she described as a rapidly expanding consulting venture. According to him, every major promise had been made face-to-face. Every delay had been explained. Every request for patience had sounded completely reasonable until the money disappeared. Karen responded with a calm smile. She leaned slightly toward her attorney and whispered something that made them both chuckle. "I noticed it. Jurors notice those things too. People often assume a courtroom is driven entirely by evidence. They forget that behavior speaks continuously, even when witnesses remain silent. When Karen finally testified, she displayed remarkable confidence. I never promised him anything. I never borrowed money. I never signed any agreement." Each sentence arrived without hesitation. Then she looked directly toward me again. And frankly, Judge, she paused just long enough for everyone to pay attention. He can't prove otherwise. Silence spread across the courtroom. Even experienced attorneys understand the danger of absolute statements. Whenever someone declares that something is impossible to prove, I immediately begin wondering what they believe has disappeared. The plaintiff's attorney remained seated. He didn't object. He didn't interrupt. He simply reached into a worn leather briefcase resting beside his chair. That movement caught my attention immediately, not because retrieving documents is unusual, because experienced trial lawyers never reach for evidence without purpose. He removed a plain manila folder, nothing dramatic, no oversized exhibit, no surprise witness waiting outside. Just one ordinary folder. Karen barely looked at it. She smiled again. If only she had known what rested inside those few sheets of paper, because within minutes, I realized this was no longer an ordinary financial dispute. It was becoming something far more revealing. And before anyone in that courtroom understood why, I ordered the first document placed in my hands. The bailiff handed me the first document, and I did something I have done thousands of times throughout my career. I looked at it without saying a word. Silence is often more powerful than questioning. People become uncomfortable when they cannot read the judge's face. They begin filling that silence with assumptions, and assumptions have a habit of exposing more than answers ever do. Karen was still sitting confidently. Her expression hadn't changed. She folded her hands together as though the hearing was little more than an inconvenience before lunch. Daniel, on the other hand, looked as though every second lasted an hour. His eyes never left the folder resting on counsel's table. I remember thinking that only one of them truly understood what was inside those papers. The plaintiff's attorney asked permission to approach, and I nodded. He explained that these were not contracts, not handwritten promises, not notarized agreements. Instead, they were business records collected over several months. Karen's attorney immediately stood. Your Honor, relevance. A fair objection. Courtrooms are not places for emotional storytelling. Facts must connect to the issues before the court, the attorney calmly answered. They establish a timeline. That response interested me. Timelines rarely lie. People forget conversations. They forget dates. But when independent records begin matching one another, they create a pattern that's remarkably difficult to escape. I began turning each page carefully. Invoices, shipping confirmations, payment records, demang summaries. Nothing looked dramatic by itself. That is another lesson I wish more people understood. The strongest evidence is rarely spectacular. It's ordinary. Small pieces that quietly fit together until the picture becomes impossible to ignore. Karen watched me with the same confident smile. She believed I was looking through meaningless paperwork. Years on the bench had taught me something else. When a witness watches the judge instead of the evidence, they're often trying to measure whether the performance is still working. The attorney asked Daniel to explain how each record connected to his claim. Daniel took a slow breath. I documented everything after the first payment. Why? The attorney asked. Because something stopped feeling right. That answer caught my attention. Victims often describe a single moment when trust begins turning into suspicion. Not certainty, just instinct. Most ignore it. Daniel didn't. He started keeping copies of receipts, screenshots, bank transfers, Condre entries. He even wrote brief notes after meetings while the memories were still fresh. At the time, he said he hoped he would never need them. I believed him. People fabricating evidence rarely admit they created records before knowing whether litigation would ever happen. Karen's attorney began cross-examination with obvious confidence. So you're telling this court that you conveniently documented everything? Daniel answered quietly. No. I documented everything after I realized I might need to remember the truth. That distinction lingered in the courtroom. I noticed several jurors writing notes. Karen rolled her eyes. Small gestures matter, not because they prove guilt, because they reveal attitude. Respect for the process is difficult to fake over several hours. Then came the emails. The plaintiff's attorney displayed them one by one. None explicitly promised repayment, none directly admitted debt. Standing alone, they appeared harmless. Karen relaxed even further. Her attorney smiled toward the jury as if to say, this is all they've got. But I wasn't reading individual emails anymore. I was reading sequence. One message referenced a meeting. Another acknowledged receiving financial information. A third thanked Daniel for his patience. Another mentioned delays that would all make sense soon. Individually, almost meaningless. Together, increasingly difficult to dismiss as coincidence. I looked toward Karen. She was no longer smiling quite as naturally. Only someone watching carefully would have noticed. Her fingers had begun tapping lightly against the table, very softly, very rhythmically. Stress reveals itself in strange ways. Some people blink more, others speak faster. Others become unnaturally still. Karen tapped her fingers. The plaintiff's attorney wasn't finished. He walked back to the manila folder and removed another stack, smaller this time. He asked permission to publish the next exhibit. Karen's attorney objected again. Hearsay. We argued the legal foundation for several minutes. After reviewing the supporting records, I overruled the objection. The exhibit would be admitted. I will never forget the expression that crossed Karen's face. Not panic, not yet. But surprise, real surprise. For the first time that afternoon, she stopped looking at me. Instead, she stared directly at the papers in her attorney's hands. That told me something. She recognized them. The attorney placed the documents on the evidence screen for everyone to see. From the gallery, I heard whispers. Nothing explosive appeared on the monitor, just what looked like routine office paperwork. Expense summaries, Tinnell tracking sheets, reference numbers. At first glance, they seemed completely unrelated to Daniel's accusations. Even I wondered why counsel considered them so important. Then I noticed a handwritten notation in the bottom corner of one page. Only 5 words, 5 ordinary words. Yet the moment I read them, I looked back at Karen. She had gone completely still. Not a single movement. Years in the courtroom have taught me that silence can confess long before words ever do. And that tiny handwritten note was about to transform the entire case into something no one inside that courtroom had anticipated. I have often said that the most dangerous evidence is not the evidence people expect. It is the evidence they forget exists. As I continued studying that handwritten notation, I noticed Karen's attorney lean toward her and whisper something. She gave a slight nod, but her confidence had begun to fracture. It wasn't obvious to anyone casually watching the proceedings. Yet after decades on the bench, I had learned to recognize the smallest cracks in a carefully constructed story. The note itself wasn't a confession. It wasn't even complete. It simply read, "Received from D.C. Hold until settlement." 5 ordinary words, but those 5 words raised an extraordinary question. If Karen had never entered into any agreement with Daniel Carter, why would an internal business document reference his initials and mention a settlement? I looked toward Daniel. He appeared just as surprised as everyone else. That mattered to me. People staging evidence usually anticipate every document that appears. Daniel's reaction was genuine confusion. He clearly hadn't expected this page to become the center of the trial. The plaintiff's attorney calmly addressed the witness. Miss Karen, have you ever seen this document before?" She answered immediately. "No," too quickly. Experienced judges notice timing just as much as wording. Truthful witnesses often think before answering. Dishonest ones frequently prepare their answers before the question is even ended. The attorney didn't challenge her immediately. Instead, he displayed another document. This one contained similar formatting, the same company letterhead, the same filing codes, and, once again, handwritten notes. This time, however, There was something even more interesting, a signature, not a full signature, just initials, K.W. Williams. Her attorney objected immediately. No foundation. A reasonable objection. The attorney responded by calling the next witness. Your Honor, the plaintiff calls Emily Dawson. A woman in her early 40s entered the courtroom carrying a binder that looked as though it had been opened hundreds of times. She walked calmly to the witness stand, took the oath, and sat without looking at Karen. I noticed Karen watching Emily far more intensely than she had watched anyone else that day. That was my first indication that this witness mattered. Emily introduced herself as the former operations manager of Karen's consulting business. Former. That single word often changes the direction of a case. Former employees sometimes arrive carrying resentment. Other times they arrive carrying something much more valuable. Records. The attorney asked a simple question. What were your responsibilities? I maintained financial files, client records, internal correspondence, and archived paperwork. Nothing dramatic, just routine office duties. Then came the question that changed the atmosphere inside my courtroom. Do you recognize Plaintiff's Exhibit 12? Emily looked at the document for only a few seconds. Yes. How? I filed it. Karen immediately shifted in her chair. Not dramatically, just enough for me to notice, the attorney continued. Whose handwriting appears on the bottom of that page? Emily answered without hesitation. Karen's. The courtroom became completely silent. Karen's attorney rose so quickly that his chair slid backward across the floor. Objection. I allowed argument. The attorneys debated handwriting authentication, business record exceptions, and foundation requirements. Legal discussions like these can seem tedious to spectators, but they are essential. Courtrooms are built on rules precisely because emotions cannot be allowed to decide cases. After reviewing the supporting evidence, I ruled that the testimony would remain subject to the weight assigned by the finder of fact. Karen stared straight ahead, no smile, no confidence, just stillness. Emily wasn't finished. She explained that Karen insisted on writing certain notes herself whenever disputes involved money. Why? The attorney asked. Emily hesitated. She glanced toward Karen for the first time. Then she looked back at me. She didn't trust electronic records. That answer lingered in the room. I folded my hands together. People often believe deleting emails erases history. It doesn't. Business leaves traces. Paper leaves fingerprints. Habits leave patterns. And patterns are remarkably difficult to hide. The attorney produced another exhibit. This time, it wasn't a business record. It was an office inventory log. At first, I wondered why it mattered. Then Emily explained every physical client file received an internal tracking number before being archived. Each number corresponded to storage boxes that had been preserved even after the business downsized. Daniel's file had a tracking number. Karen's attorney immediately objected again. There is no such file before this court. Emily quietly answered before anyone else could speak. There wasn't supposed to be. Every juror looked up. Even the spectators leaned forward. I felt the entire courtroom change. The attorney asked the obvious question. What do you mean? Emily took a slow breath. Because someone instructed me to destroy it. For the first time all afternoon, Karen's face lost every trace of composure, and before I could ask the next question, the bailiff walked quickly toward the bench, carrying a sealed envelope that had just been delivered to the courtroom. The name written across the front made every attorney stop speaking. It was addressed to me, and the return label belonged to a storage company no one had mentioned until that very moment. In all my years on the bench, I have learned that surprises rarely arrive at convenient moments. They appear when everyone believes the story is already written. The bailiff handed me the sealed envelope. I examined the return address before opening it. It belonged to Harrison Secure Records, a document storage company located nearly 40 miles from the courthouse. Neither attorney had mentioned it during discovery, neither witness had referred to it, yet somehow an envelope from that facility had arrived in the middle of trial bearing my courtroom number and the case caption. I looked toward counsel. Does either side know anything about this? Both attorneys answered no. Karen's attorney looked genuinely puzzled. The plaintiff's attorney seemed equally surprised. That immediately caught my attention. When both sides are caught off guard by the same piece of evidence, a judge proceeds carefully. I broke the seal. Inside was a certified letter accompanied by several photocopied records. The letter explained that Harrison Secure Records had recently conducted an internal inventory audit after a change in ownership. During that audit, employees discovered a storage box that had been mistakenly cataloged under an inactive account rather than being destroyed according to a previous disposal request. One sentence immediately stood out. The box remains sealed because company policy requires judicial authorization before releasing materials connected to pending litigation. I paused. The courtroom became so quiet that I could hear paper shifting as jurors adjusted in their seats. The storage reference number printed on the letter matched the number Emily Dawson had testified about only minutes earlier. Coincidence, perhaps. But judges are trained not to rely on coincidence when facts can be verified. I turned toward Emily. Miss Dawson, have you seen this tracking number before? She leaned forward slightly. Yes, Your Honor. How certain are you? I assigned it myself. Karen lowered her eyes, only for a moment, but I noticed people often think the important reactions occur after dramatic accusations. They don't. The important reactions occur when objective facts begin confirming testimony. That is when carefully rehearsed stories begin colliding with reality. Karen's attorney immediately requested a recess. I denied the request. The jury deserved to hear the explanation while memories remained fresh. The plaintiff's attorney asked Emily one final question. Was Daniel Carter's file supposed to exist? Yes. And why wouldn't it exist today? Because Karen instructed me to prepare it for destruction. Karen stood abruptly. I never said that. It was the first time all afternoon she had interrupted proceedings without consulting her attorney. That interested me more than the interruption itself. Emotion often arrives when preparation ends. I calmly instructed everyone to remain seated. Then I addressed Karen directly. You will have every opportunity to testify again if necessary. She slowly sat back down, but something had changed. The confidence that had filled the courtroom earlier had vanished. Now she appeared to be calculating, not explaining, calculating. The plaintiff's attorney requested permission to contact Harrison Secure Records immediately. After hearing both sides, I allowed a brief recess solely for verification. Court personnel placed the call from chambers while counsel remained present. I listened carefully. The storage manager confirmed every detail contained in the letter. Yes, the box existed. Yes, it remained sealed. Yes, no one had opened it since it entered storage more than 3 years earlier. Most importantly, the chain of custody records showed every person who had handled the box. One name appeared repeatedly, Emily Dawson. Another appeared only once, Karen Williams, no one else. When we returned to open court, I informed the parties that the records had been independently verified. A murmur spread through the gallery. Karen stared motionless at the defense table. Her attorney leaned close and whispered rapidly. She barely acknowledged him. I've seen that expression before. It appears when someone realizes the courtroom is no longer debating opinions. It is about to examine history. The plaintiff's attorney wasn't interested in dramatic speeches. He simply asked me to issue an order requiring the storage company to deliver the sealed box to court the following morning. Karen's attorney objected. He argued relevance delay procedural concerns. Some of those arguments carried legitimate legal weight, but one fact outweighed them all. If the box contained business records directly connected to the claims before the court, justice required that the truth, not convenience, guide the proceedings. I granted the motion. The box would be delivered under seal. No one would examine its contents until both parties were present. As I announced the ruling, I watched Karen carefully. She closed her eyes, just for a second. Then she exhaled slowly, not with relief, with resignation. That single breath stayed with me. Experienced judges learn that people sometimes reveal their greatest fears without saying a single word. Court adjourned for the evening. Most people filed quietly toward the exits. Daniel stopped briefly near counsel's table, looking exhausted rather than victorious. Emily left without speaking to reporters gathering outside. Karen remained seated longer than anyone else. She never looked toward Daniel. She never acknowledged the jury. She simply stared at the empty witness stand as though replaying every answer she had given that day. As I walked back toward chambers, I found myself thinking about something I rarely admit. I wasn't wondering what would be inside the sealed storage box. I was wondering whether Karen already knew. Because if she did, then tomorrow's proceedings were about to expose far more than a financial dispute. They were about to reveal why someone had tried so hard to make sure that box was never opened. I barely slept that night. Judges are trained to separate emotion from law, but there are rare cases that refuse to leave your mind once the courtroom lights go dark. This was one of them. The next morning, I arrived earlier than usual. The sealed storage box was already waiting inside the evidence room. Its chain of custody paperwork had been verified. The security tape remained intact. Every signature matched the records Harrison Secure Records had provided. No one had touched its contents in more than 3 years. I remember standing there for a brief moment before entering the courtroom. Not because I expected something dramatic, because experience had taught me that the quietest evidence often carries the loudest truth. When court came to order, every seat in the gallery was occupied. Word had spread overnight. Reporters filled the back rows. Even attorneys from neighboring courtrooms quietly slipped inside during recesses just to observe. Karen entered differently that morning. Gone was the confident smile. Gone was the relaxed posture. She walked with measured steps and avoided looking toward the evidence table altogether. Daniel looked exhausted. Hope can be just as draining as fear. I instructed the bailiff to place the sealed box where everyone could see it. No one spoke. I carefully broke the evidence seal. Inside were several neatly organized folders. Nothing appeared unusual. No dramatic photographs, no hidden recording device, no shocking confession. Just files, ordinary office files. One by one, I removed them at records, vendor correspondence, archived invoices. Then I reached the folder bearing a handwritten label, Daniel Carter. For several seconds, nobody moved. I opened it. The first document was exactly what Karen's attorney had insisted never existed, a written payment schedule, not signed, but initialed. The initials matched the ones Emily Dawson had identified the previous day. Kebu Karen Williams, Karen's attorney, immediately stood. Your Honor, initials alone prove nothing. He was correct. Initials alone are rarely enough, which is why I kept reading. Behind the payment schedule was an internal review form. It summarized Daniel's investment, expected repayment dates, and projected business profits. Then came something even more significant, a typed memorandum prepared for internal accounting. One sentence immediately captured everyone's attention. Maintain Carter files separately until reimbursement issue is resolved. The gallery erupted into whispers. I struck the gavel once. Order returned. I looked toward Karen. She was staring directly at the folder, not blinking, not speaking, just staring. Then I found the document that changed everything. It wasn't lengthy. It wasn't dramatic. It wasn't even intended for outside eyes. It was a yellow legal pad page attached to the inside cover with a paperclip, handwritten, dated. Karen's handwriting appeared across the top. I read silently first. Then I read it again. Years on the bench teach you to verify before reacting because once words leave the bench, they cannot be taken back, the note read. Daniel keeps asking for written confirmation. Do not send emails. Handle everything on paper until funds clear. I slowly placed the page on the evidence screen. The courtroom froze, domiciled silence. Not even whispers. Karen's attorney looked at the note, then looked at Karen. For the first time during the trial, he seemed genuinely unable to speak. I watched his expression carefully. Experienced attorneys usually know every important document before trial begins. This one had surprised him too. Karen finally broke the silence. That's not what it means. No one had asked her a question. Those 6 words came entirely on their own. I have noticed something throughout my career. People rarely volunteer explanations for evidence that doesn't concern them. The plaintiff's attorney approached carefully. Mrs. Williams, whose handwriting is this? Karen hesitated, just long enough. I don't know. Emily Dawson was recalled briefly. She examined the page. I watched Karen write this. Karen shook her head repeatedly. No. Emily didn't raise her voice. She simply answered with remarkable calm. You always used yellow legal pads for internal instructions. Another pause, then the attorney asked one final question. Why do you remember this specific note? Emily looked toward Daniel. Because after Karen wrote it, she told me to remove his file from the normal archive. I felt every juror's attention sharpen, patos, everything was becoming a pattern. No single document established the entire claim, but together, the payment schedule, the accounting memorandum, the handwritten instructions, the archived file, the destruction request, the storage records, every independent piece supported the next, like links in a chain that had remained hidden until someone finally connected them. Then came the moment I will never forget. Karen slowly leaned toward the microphone. She wasn't looking at me. She wasn't looking at the attorneys. She was looking directly at Daniel. In a voice barely above a whisper, she said, I never thought anyone would find that file. No attorney had asked the question. No one prompted the statement. The words simply escaped. The courtroom seemed to stop breathing. Even Karen appeared to realize what she had just admitted. Her attorney closed his eyes. Daniel lowered his head into his hands. The jurors looked from Karen to me, waiting for the law to catch up with the truth. And at that moment, I knew the final phase of this trial would no longer be about proving what happened. It would be about deciding what justice required after the truth had revealed itself with Karen's own words. There is a moment in every courtroom where the search for truth ends and the responsibility of justice begins. For me, that moment arrived the instant Karen whispered, I never thought anyone would find that file. People often ask whether dramatic courtroom confessions immediately decide a case. They don't, not by themselves. A judge cannot substitute emotion for evidence. The law requires discipline, especially when emotions are at their highest. That is why I did not react to Karen's statement with an immediate ruling. Instead, I looked at every exhibit once more, the payment records, the archived file, the accounting memorandum, the handwritten instructions, the storage company's chain of custody records, Emily Dawson's testimony, Daniel Carter's documentation, and finally, Karen's own words. Each piece reinforced the next. No single document carried the entire burden. Together, they formed a complete picture that was remarkably difficult to dispute. Karen's attorney requested permission to speak privately with his client. I granted a brief recess. When the parties returned, the atmosphere had completely changed. The confidence that had defined Karen's defense was gone. Her attorney stood slowly. "Your Honor," he paused. "My client wishes to clarify portions of her earlier testimony." That sentence told me everything I needed to know. Clarify. Lawyers choose words carefully. He did not say correct. He did not say explain. He said clarify. Her voice was softer than it had been at any point during the trial. I wasn't completely truthful. No one moved. No one interrupted. She continued. "When Daniel invested, I believed the business would succeed. I intended to pay him back. But when things started falling apart," she stopped speaking. I waited. Silence often allows honesty to continue where pressure cannot. Finally, she lowered her head. I kept telling myself I could fix it before he found out. That sentence revealed something important. Not every deception begins with malicious intent. Some begin with pride. Others begin with fear. Then they grow. One lie demands another. One hidden document requires another hidden document. Eventually, protecting the lie becomes more important than solving the original problem. I have seen that pattern more times than I wish to remember. The plaintiff's attorney asked only one final question. "Did you instruct that Daniel Carter's file be removed from the normal archive?" Karen closed her eyes. "Yes." "Did you authorize its destruction?" A long pause followed, then, "Yes." Daniel never celebrated. That is something I still remember. Many people imagine victorious plaintiffs smiling after admissions like these. Daniel didn't. He simply sat quietly. His shoulders relaxed for the first time since entering my courtroom. Sometimes people are not fighting for money. They are fighting to hear the truth spoken aloud. After reviewing every exhibit and considering all testimony, I delivered my ruling. I found that Daniel had established his claim through credible documentary evidence, corroborating witness testimony, and Karen's own admissions. Judgment would be entered in his favor. Karen was ordered to repay the outstanding amount together with allowable costs under the law. As I finished reading the decision, I looked toward both parties. Daniel appeared relieved, not triumphant. Relieved, Karen looked defeated, not because she had lost money, because the story she had carefully constructed had collapsed under the weight of ordinary paper she believed no one would ever see again. As the courtroom slowly emptied, I remained seated for a few moments. Judges rarely speak after a ruling, but that afternoon I felt compelled to leave everyone with one final observation. I said, people spend enormous energy hiding evidence when they should spend that same energy telling the truth. No one answered. No one needed to. Years have passed since that case. I have handled more complicated lawsuits, larger financial disputes, far more serious crime, yet this case remains with me because it taught a lesson that reaches far beyond any courtroom. Technology changes, businesses change. People learn new ways to conceal information, but character always leaves a record somewhere. Sometimes it's an email, sometimes it's a witness. Sometimes it's a bank transfer, and sometimes it's nothing more than an ordinary sheet of paper quietly waiting inside an old storage box. Karen believed proof had disappeared. She believed time had erased accountability. She believed confidence could replace truth. She was wrong. If there's one lesson I hope you take from the story you've just heard, it's this. Truth rarely needs to shout. It survives in small details that people overlook. A receipt no one throws away, a note someone forgets, a file placed in the wrong box. A single sentence spoken when the pressure finally becomes too much. After decades on the bench, I no longer believe justice depends on perfect people. I believe justice depends on patient facts. Because facts do not become weaker with time, they simply wait for the day someone is finally willing or forced to face them. And that is exactly what happened in my courtroom.